All right, let's dive right in. If you're working in the gun violence prevention space, there's a critical new decision from the Second Circuit that you absolutely need to have on your radar. It's called U.S. versus Simmons, and frankly, it provides a powerful, maybe even unexpected, legal blueprint for defending firearm laws in this new post-Bruen world. So in this explainer, we're going to give you that detailed legal breakdown that you can actually use in your work.
So here's our game plan. We're going to walk through the court's reasoning step by step. We'll start with the case itself, then unpack the two-step Bruen framework that every court has to use now. We'll look at the surprising way the court handled step 1, the question of who the people even are, and then get into the real heart of the matter, the history of disarmament in step 2. That's going to show us exactly why this law was upheld and, most importantly, leave you with some really clear takeaways for your advocacy.
Okay, let's set the stage. This case, United States versus Simmons, this isn't just some run-of-the-mill legal dispute. It's a landmark test of a cornerstone federal law, and it's one of the first major challenges in the wake of the Supreme Court's Bruen decision.
So here's the story, and it's pretty straightforward. The defendant, Valdez Simmons, had a prior conviction for a domestic violence misdemeanor. Now, years later, he's found with a pistol in New York City. This triggers a federal law, Section 922G9, which says you can't have a firearm if you have a conviction like his. So Simmons' defense was essentially a full frontal constitutional assault. He argued that this law, under the new Bruen standard, completely violates his Second Amendment rights. And just like that, you have a major public safety law on a collision course with the Supreme Court's new test.
Now, to really get what happened in Simmons, you first have to understand the rulebook the court was playing by, and that is the two-step framework that came out of the Bruen decision. It completely rewrote how courts have to look at Second Amendment cases.
And this is absolutely crucial to understand. The old way of doing things, balancing a law's public safety benefits against the burden on gun rights, that's gone. It's off the table. In its place, we have this very rigid two-part test. Step 1, does the plain text of the Second Amendment even cover this person's conduct? If the answer is yes, then the burden shifts entirely to the government for step 2, and the government has to prove that the law is, and I quote, consistent with the nation's historical tradition of firearm regulation. That's it. It's a history-only test now. That's the whole ballgame.
So let's see how the court applied step 1. Because this is where the case takes its first really critical turn, and it leads to a conclusion that might feel a little bit counterintuitive, but it's legally essential to grasp.
Okay, so the court makes two huge findings here. First, it says, yes, Simmons' conduct, just possessing a handgun, is generally covered by the Second Amendment's text. No surprise there. But here's the big one. It also held that Simmons himself, even with his domestic violence conviction, is still part of the people that the amendment protects. The court's logic was that the people means all members of the political community, and a misdemeanor conviction doesn't kick you out of that club. Now, this sounds like a win for Simmons, right? But what it really was a strategic move by the court to concede this point and shift the entire weight of the case onto step 2.
And the court actually spells out its reasoning by pulling this quote from its own very recent decision in Zerka. And what this quote tells us is that the key question isn't, are some people just not covered by the Second Amendment? No, the real question is, does history show that Congress has the power to take guns away from certain groups of people? And that framing is everything. The focus immediately shifts from an individual's rights to the legislature's historically justified power to regulate.
So, with step 1 basically decided in Simmons' favor, the whole case came down to step 2. The government now had the entire burden of proof. It had to show that this law, Section 992G9, lines up with our nation's historical tradition of firearm regulation. This is where the government won. And how it won is honestly a masterclass for all future litigation.
So how did they do it? How did the government meet this incredibly high bar? Well, its victory wasn't built on just one argument. It was built on two incredibly powerful legal pillars. Both of them are from super recent landmark cases that you absolutely have to know inside and out.
Pillar number 1 is the Supreme Court's 2024 decision, United States versus Rahimi. In Rahimi, the court upheld a different but related law, the one that disarms people under domestic violence restraining orders. It found a clear historical tradition of disarming individuals who pose a, quote, clear threat of physical violence. The court looked back at old laws like surety laws and going armed laws, and crucially,
It even noted that these historical laws were sometimes used to prevent spousal abuse. So Rahimi gives us the core principle. If you're dangerous, the government has a historical power to disarm you.
Now, pillar number 2 is the Second Circuit's own 2025 ruling in Zerka versus Bondi. Now, if Rahimi was about disarming one person after a judge says they're dangerous, Zerka took it a giant leap further. It upheld the federal ban on felons having guns, and in doing so, it affirmed that legislatures can impose what are called status-based categorical bans. This means they can disarm entire classes of people, not just individuals, that the legislature presumes to be dangerous. The big takeaway from Zerka is huge. You don't always need a judge to make a one-by-one finding of dangerousness. A legislative judgment about an entire category can be enough.
All right, so now let's see how the court put these two pillars together, because this synthesis is really the brilliant legal architecture of the Simmons ruling, and it creates this incredibly strong argument for upholding these kinds of laws.
The court's logic was just so elegant. It basically went like this. Okay, Rahimi gives us the historical tradition of disarming dangerous people. Zerka gives us the historical tradition of legislatures doing this on a class-wide basis. So if you put those two together, it's perfectly constitutional for Congress to disarm an entire class of people that it determines is dangerous. In this case, that class is people convicted of domestic violence misdemeanors. The conclusion just becomes almost self-evident.
So Simmons' team tried one last argument. They said, hey, hold on. A misdemeanor is not a felony. It's just not serious enough to strip someone of a constitutional right. And the court just wasn't buying it. They flatly rejected this. They said the label, whether you call it a felony or a misdemeanor, is totally irrelevant. What matters is that Congress, the legislature, made a specific finding that this type of crime, a crime of domestic violence, signals dangerousness. And the court gives deference to that legislative judgment, a judgment that's obviously grounded in mountains of data.
And this right here is the final piece of the puzzle. The court wraps it all up by saying that Section 922G9 isn't some strange modern law that's out of step with the Second Amendment. No, it fits, and I'm quoting the court here, squarely within this nation's history of disarming those considered to be a danger to the physical safety of others. It forges that direct link from a modern statute back to a historical tradition, and that is exactly what Bruen requires.
So, after all that dense legal analysis, what does it mean for you? As an advocate on the front lines, what should you take away from this pivotal decision? Let's boil it all down to the most critical, actionable points. Okay, this is your new toolkit, straight from the Second Circuit. Here are the 5 principles. The big picture is this. Dangerousness is the constitutional standard, and legislatures, not just judges, can decide which categories of people meet that standard. Don't get bogged down in labels like misdemeanor. The focus is on the dangerous conduct. And the history you need isn't a carbon copy of an old law, but a broad tradition of legislative power to disarm threats. You need to internalize these points. This is your court-affirmed foundation for the work ahead.
And that brings us to our final thought. You see, the Simmons decision isn't just an ending. It's really a beginning. It essentially gives a constitutional seal of approval to the logic that a legislature can identify a dangerous class and disarm them. And that, of course, leads to the powerful, forward-looking question for all of us in this field. If that's the standard, what other data-driven, risk-based categories does this logic support? The answer to that question is going to shape the next generation of legal advocacy in gun violence prevention.